Welcome to Judica County. I'm your host, Cassandra Nicholas, and I'm here with attorneys Taylor Scruggs-Smith and Kimberly Lott. We're all attorneys with Whitaker and Hamer, your law firm for life, with offices across the state of North Carolina. Today, we're going to touch on a specific family law topic regarding equitable distribution. Can one of you please tell me a little bit more about what equitable distribution is?
Sure. So equitable distribution is how the court splits up the marital estate. So anything that was bought during the marriage, anything that was contributed to during the marriage, pretty much anything that came into the marriage material-wise, that's what the court is planning to split. And the reason we call it equitable is because equitable doesn't mean equal. The court does its best to assume a 50-50 split, but there are factors that are in the statute that could change that to be an unequal distribution because that's more fair to one spouse or the other.
What are some of those factors?
Some of those factors can be marital misconduct, and that's one of the biggest ones. The other thing that goes along with that is equal, because we say equitable instead of equal because we don't take a car and cut it in half and give each party two parts. So we might have one party get a car, the other get another car. We might have one person get this retirement account and another person get this retirement account. At the end, it's about equalizing how the value that each person gets. And that also takes into account whether it is a cash amount, which is very different than an amount that's in a retirement account. So those dollars are not the same. So that's part of the equitable part of the distribution.
Are there formulas involved? Like, how do you figure that out? That seems like a lot of work.
So the general go-by is that everything's valued as of the date of separation. So for instance, in retirement accounts, like let's say a party had the retirement account before they got married, we would look at the date of marriage value versus the date of separation because parties are only able to get half of what went into that retirement account during the marriage. So whatever you had before you got married doesn't count. But in instance for matters like a house, it's most of the time the market value of the house because most people aren't getting
the date of separation.
Sometimes that's, I believe, as of the date of trial because most people aren't having a appraisal done every year. And when you first separate, nobody thinks about getting an appraisal. But the court has to have some recent value. So it ends up being the market value at the time you're about to head into court.
What if one party did purchase that house like right before marriage?
That's a good question. If the way that the laws in North Carolina are set up, if one party bought the house before they got married and they left it just in their sole name and they never gave it to the marriage, then the spouse would get a lesser amount out of that house. They would be entitled to what the value was during the time of the marriage. Now, if the person who owned the house titled it to the other spouse, then now that has made that a full marital asset and it would be divided 50-50 at that point.
So they'd be looking at the value of the house before marriage versus the value of it at separation if it was purchased before marriage and they weren't added to the title?
Sure, and there are several different factors that go into that. One of the common misconceptions that people have is if I was single and I sold a house right before we got married and I took the money from that house and I put it towards a down payment of our marital home that we purchased together, then aren't I entitled to that amount that was separate beforehand? The answer in North Carolina is no. The answer in North Carolina is if you give that money to the real estate that is part of the marriage, then you lose that being your separate property. That can be different for other things that you purchase, but when it comes to real estate, it becomes an equally shared asset.
And that kind of goes to the kind of big presumption when it comes to North Carolina. North Carolina has a presumption that anything purchased during the marriage is presumed marital property. And that presumption is a big thing because that means if you're trying to argue it's not marital property and it's separate, the burden is on you to prove that because the court is going to assume it's marital property unless somebody presents enough evidence to prove it's not.
Are there ways to successfully prove that it was separate even though you bought it during the marriage?
Yes, and that requires a lot of kind of accounting and tracing where the money came from for something that was purchased. So obviously in real estate it's different, but when it comes to other things, it could be, okay, this money was always in a separate bank account, or this money came from an inheritance or anything like that. But you have to trace those funds. So you have to find the original deposit and then trace how that went towards the purchase. So it's very detailed.
That's easier to do if spouses have separate bank accounts?
Yes. So if it was a joint bank account, that becomes a lot more difficult, especially if you primarily had the joint account for most of the marriage.
Do you have anything else you'd like to tell folks that know that they'll need to have equitable distribution?
Yes.
Any advice?
Yes. One of the things that we hadn't covered yet was there are assets that you have to divide, but there are also debts that you have to divide. And the way a lot of people live their lives nowadays, they're living very much in debt. So people sort of come into the equitable distribution, and sometimes you're just dividing a whole bunch of debt.
How does North Carolina deal with student loans?
Great question. So debt in a marriage, if the debt is in one party's name, the law assumes that it's that person's debt. You can overcome that presumption by saying this money, let's say it's a credit card debt, this money was used for family contributions, food, clothing, vacations, things like that. When it comes to student loans, again, it depends. If there were student loans that you incurred before you got married, they're going to be your student loans. You're going to keep those. However, if a spouse went to school while they were married, it's going to depend, what did the other spouse do to contribute to that? You know, did they stay home and raise children? Did they work? Did they help to contribute to that? Was the student loan taken out to cover household bills, or was it just taken out for tuition? And then how long did you stay married after the person got their degree? So we're lawyers. So if I went to law school and my spouse and I separated the day after I walked out of law school, I might be more responsible for my student debt than my spouse would be because he's not, I'm getting the value of that education.
Exactly. Of you being a lawyer.
But
Right.
like in a lot of situations like nurses, like if you went through all those schools and then you got a better job and for like the next 5 years after that, you were actively contributing to the marriage with that higher income, that could be seen as a marital asset that you did something for the benefit of the family and you took out that debt for the benefit of the family and the family has benefited from it. So it depends is kind of always the lawyer go-to answer because it does depend on several factors. And speaking of factors, I want to go back a little bit to those equitable distribution factors. There are 16 of those. But the thing is about those factors is that they are all in their own way difficult to prove, but also each one of them on their own could be enough to establish an unequal distribution, meaning even though the court tries to split things 50-50 in terms of valuations, we could say this needs to be split 60-40 because of these factors.
Because that's more equitable and fair.
So that does include things like somebody staying at home to take care of the kids for most of the marriage while the other party went out and worked so they didn't have to pay for childcare. A lot of things, it's all economic based. So a lot of times we get questions about, well, how the affair, somebody had an affair. Well, the affair itself doesn't affect equitable distribution, but if they used marital funds to go take trips to have that affair or to pay for dinners for that affair, that could be a misuse of marital funds, which is one of those 16 factors.
And I will also clear up another big misconception. A lot of people come to us and they say, but she abandoned me or he abandoned me. And it's a big buzzword for equitable distribution, but in reality, abandonment, first of all, is it's not just one person leaving the marriage, and it also doesn't tend to have much of an effect on the equitable distribution. It can have an effect on other things like custody and alimony and things like that, but it doesn't really have that much of an effect on equitable distribution. North Carolina tends to be sort of a no-fault state when it comes to equitable distribution. So,
is there an interplay between how equitable distribution is determined in alimony? Equitable distribution is just the assets and debts from during the marriage, but alimony is income moving forward.
So there is some interplay because sometimes alimony is awarded first or equitable distribution could be awarded first. And obviously you're splitting up a household. So that's going to change everybody's bills. That's going to change your budget. That's going to change how you're going to retire. That could change your whole portfolio when it comes to your finances. So that could play into if we're expecting somebody to get a large amount of windfall from an equitable distribution, then maybe we give a smaller alimony because you're already getting all these other funds up front. So there is some interplay between them, but they are two separate claims. So sometimes you will have clients that are only fighting or filing for alimony and equitable distribution has already been handled. So if it doesn't go through a court and there's not like a full thing, or if it's not in a separation agreement, it's kind of hard to determine how much it played into, but they do have some interplay. But I always like to remind people there are two separate claims. So if you don't file for one or you don't bring up one, that doesn't automatically mean it affects the other.
It sounds very complicated and seems like you definitely need a good, experienced attorney to deal with those 16 factors of equitable distribution. So thank you for telling us more about them, and I hope folks reach out to you to learn even more and have you take care of those. We thank you for joining us on this episode of Judica County. If you find yourself in need of legal assistance with equitable distribution, give us a call at 919-772-7000 or contact us on our website at wh.lawyer. Again, we're Whitaker & Hamer, your law firm for life.